Sarah Boone is back, and this is the first time that she's taken the stand where we actually get to hear some of her thoughts and where the defense plans on taking her through the trial. So I thought that maybe we could go over and review it together, see their new points, and see what the state prosecutors have to say.
She was previously sworn at the beginning.
Judge, I'll be here.
Yes, sir. Hey, the deputy's got a mover. Ma'am, you've already been sworn. Counselor, you may proceed.
Ma'am, would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son.
All right, so already she's saying that she was in a state of confusion and just the mass amounts of people that were there and the different things that they were doing. But I have to say, what did she expect when somebody had been killed? It turns into a crime scene, so they have to go through it all. And I'd be really surprised if she honestly was confused by that. And I mean, considering she was a straight A student, she should know better, right? But it also lets you know that they're setting up for her to claim confusion and now saying that she has worry for her dogs and her son. We know that she did not have her son most of the time, and he was not there for this. And I also thought it was interesting that she brought up the dogs right off the bat. In other body cam footage that we've seen, Jorge Torres actually was concerned about the dogs and the back door being locked on one of the occasions that he was arrested. So I think it's interesting. This is the first time that she's ever brought them up at all.
I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm-
First of all, their mics are working great, but Sarah's isn't. So sorry if you don't appreciate the audio in this. I don't either. Hopefully they get that fixed before the trial starts. But it's pretty interesting how immediately fired up both attorneys and the judge has gotten. Sarah brought up the fact of still being hungover, which they absolutely are going to try to bootstrap that into the trial. And that's why the judge said that. They definitely are forming a narrative, which is interesting because, once again, as we know, Sarah claims that she was not intoxicated, that she and Jorge split a bottle of wine, and that was it, and that none of her behaviors had anything to do with alcohol or being under the influence. So now they're kind of backtracking and seemingly going to put that out in the trial.
going to sustain the state's objection.
Relating to the intoxication?
Yes.
Okay.
It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it.
Okay.
Objection sustained and it's stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then, were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away, I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesell asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Objection calls for, she's speculating.
Sustained.
What was the next?
So not that I'm a body language expert, but if you notice every single time there's been objection and is sustained, she will make a pursing of her lips, and it's almost like she's trying to let out that she disagrees with it or is unhappy about the call from the judge. I definitely think that she's trying to keep her energy level low and come across a certain way. As we know, Sarah doesn't usually come across very well, especially to the public, and I bet that this was a big conversation with her lawyer leading up to this hearing.
Thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Copesell,
How did you unlock it?
she handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesell was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
Yeah, they didn't indicate that she's a person of interest, but wouldn't that be applied? She was the only one home with Jorge. She already said what had happened and that she locked him in. So just because they didn't come straight out and say, well, we're looking into you, we may be detaining you at some point, she is the only person that could be of interest in this.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
For mental state, it's not over.
Sustained.
Go ahead.
Objection sustained.
There's no pending question at this time.
Okay. You were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
Could you imagine being the detective in this and giving Sarah Boone your phone number? I mean, it was obvious and 100% Sarah not only would call, but probably call many times because she seems very clearly worried about herself in this. She wanted to make sure that there wasn't anything pending towards her. She was concerned about Jorge's family coming after her. But still, in all of this, there hasn't been any mention about sadness or devastated over his death. It's just all around Sarah.
I told her, in all honesty, that I felt that she was trying to trick me.
Objection. Your relative understatement.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Objection. Answered.
Overruled. You may answer the question, ma'am.
Judge, did you call for a yes or no? She said yes, and now I don't know what's pending and how to object to it.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator, where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else.
So they're setting this up as if she didn't know she was going to be having an interrogation or questioning, which she didn't have to know. The police don't really have to notify you that you're coming in to be interrogated. But it is interesting because she says about her list of questions that she had for them, which we do see in the interrogation video of her. If you haven't seen it, I'll link it below in the description. It's pretty interesting to watch. But so she was going to initiate a conversation anyway because she had made out a list and had all these questions for the detectives. So them trying to frame it that the detectives just did this and she had no idea and she was ambushed. Well, she was also planning on having a conversation with them. So I think that kind of kills any motivation in that direction for the defense.
Prior to that time, was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room?
Correct.
And then we've got the video on that. Now, you and I have watched the video,
Yes.
correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said, normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read, having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
It's all interesting because obviously she would need to ask that, and makes me want to go back over and see if that part was at all recorded during the interrogation. I don't remember that beginning part being recorded, but it also kind of downplays what they were trying to do, which was say that Sarah probably was still intoxicated and wasn't in a good state of mind, but now they're going to let her say that she wasn't read number 9. But the prosecutors can easily turn around and say, well, if you're saying she doesn't remember a lot because she was intoxicated, maybe she didn't remember that. So the way that it's so far getting put together, the state can easily tear this down.
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone, did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant, she's in custody.
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
And that's exactly what I was just saying before. It doesn't matter if she didn't realize that she was in custody or being interrogated. They are allowed to proceed, and that's what was happening. So there isn't a defense for that. And as much as he thinks it was wrong, it's not wrong. They're legally allowed to do what they did.
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space. She was.
That all goes to
she was
whether or
being
not-
let me finish. She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that, under Ramirez, as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation.
Okay.
I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
Subjectivity matter.
excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
Doesn't.
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Objection relevant.
Sustained.
Did you have some questions for them at the end?
I did.
Wasn't just at the end. As she said, she walked in there with a list of questions. So conversation was going to happen anyway.
Did you feel like you had a choice in answering their questions?
Objection relevant.
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Objection relevant.
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
Yeah, if they are going to try to lead this trial in Sarah Boone's feelings of what matters and how she felt, they're going to lose so fast. There's no way that any of this should be subjected because of her feelings and what she understood. That's just not how the law works. And especially in Sarah Boone's case, I mean, we have seen how indifferent she is with the death of Jorge and the lack of feelings and emotions. So I just think this is a very bad path for the defense to take. And it sounds like they're going to try to take that in the trial, which is not going to go well because Sarah's already so unlikable that the jury is just going to hear all of this and think it's nonsense.
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then?
Did alcohol affect my conversation with her?
there's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
He stumped her.
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she,
Oh, all right. I have to pause on this. Everything that I've read about her new lawyer, he seemingly is a great lawyer, but he's kind of bombing right now. He is not giving good answers and legal answers to be able to object and to try to stop questioning because she already answered according to him. And once again, it's kind of getting wrapped around in Sarah's feelings, and that's not law, and that doesn't work in this case. So it's interesting that the judge told him to think of a legal way to object to this, and he is silent.
said she didn't know what it
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Judge,
Regarding the,
I would object to that.
It is
I'm not
true.
understanding what the
She's
question-
changing.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copsel's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this
Exactly
afternoon.
what's happening.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand, I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone.
So, what do you think of her new lawyer and the tactics that they're going to be using at the soon, man, we're just a few weeks away for the trial? I think that they are really going to struggle with this defense. Just like with the abused wife syndrome that we know that they for sure will be doing during trial. It's going to be really hard to get people to look away from the facts, to hear feelings on it, especially feelings for Sarah Boone. So, I mean, always interesting, but I think that it's not going to go well.